Hello everyone, I am Sweksha Sharma and you are watching LawPutra YouTube channel. Today we will be discussing one of the important article of our constitution, that is Article 21. The right that has been held to be the heart of constitution is Article 21. This article states that no person shall be deprived of his life or personal liberty except according to a procedure established by law. Thus, this article secures two rights of the citizen. First one is the right to life and second one is the right of personal liberty. Article 21 comes under Part 3 of the Indian Constitution and is one of the important fundamental rights guaranteed to all the citizens of India. In this video, we will be discussing various rights and liberties that are part of Article 21 along with some important case laws. Article 21 is the most organic and progressive provision in our living constitution. The foundation of our law, Article 21, can only be claimed when a person is deprived of his life or personal liberty by the state as defined in Article 12. Violation of the right by private individual is not within the purview of Article 21. This article uses three crucial expressions. Those are right to life, right to personal liberty, and procedure established by law. Let us discuss it one by one. First comes the right to life. The right to life in Article 21 of the Indian Constitution does not mean only an animal existence or the mere act of breathing. It guarantees the right to a dignified life. Some of the rights that are currently included in the ambit of Article 21 includes right to live with human dignity, right to a decent environment including pollution-free water, air, and protection against hazardous industries, right to livelihood, right to privacy, right to shelter, right to health, right to free education up to 14 years of age. There are several other rights that are included along with these rights. One of the important case law under right to life is Maneka Gandhi versus Union of India 1978. In this case, the Supreme Court overruled its judgment of the Gopalan case. Now here, what was the Gopalan case? Here, the Supreme Court has taken a narrow interpretation of Article 21. It held that the protection under Article 21 is available only against arbitrary executive action and not from arbitrary legislative action. This means that the state can deprive a person of the right available in Article 21 based on a law. By taking a wider interpretation of Article 21 in the case of Maneka Gandhi versus Union of India, Supreme Court ruled that the right to life and personal liberty of a person can be deprived by law on the condition that the procedure prescribed by that law is the reasonable, fair, and just in nature. Further, it clarified that the right to life does not merely mean animal existence. It was held that all those aspects of life which go to make a man's life meaningful, complete, and worth living will be included in this. Then comes personal liberty. Liberty of a person is one of the oldest concepts to be protected by national courts. The English Magna Carta provides that no freeman shall be taken or imprisoned but by the law of land. This smallest article of 18 words has the greatest significance for all those who cherish the ideas of liberty. What can be more important than liberty? In India, the concept of liberty has received far more expensive interpretation. The Supreme Court of India has rejected the view that liberty denotes merely freedom from bodily restraint and has held that it encompasses those rights and privileges that have been long recognized as being essential to the orderly pursuit of happiness by a free man. The meaning of term personal liberty was considered by Supreme Court in the Kharak Singh case, which arose out of the challenge to constitutional validity of UP police regulation that provides for surveillance by way of visit and secret picketing. Oddly enough, both the majority and minority on the bench relied upon the meaning given to the term personal liberty by an American judgment, which held that the life meant something more than mere animal existence. The prohibition against its deprivation extended to all those limits and facilities by which the life was enjoyed. And comes the third main crucial expression under Article 21, that is, procedure established by law. The expression procedure established by law has been the subject matter of interpretation in a case. A survey of these cases reveals that courts in the process of judicial interpretation have enlarged the scope of this expression. The Supreme Court took the view that procedure established by law in Article 21 means procedure prescribed by law as enacted by the state and rejected to equate it with the American due process of law. Now, what Supreme Court said about the procedure established by law? The Supreme Court has widened the scope of procedure established by law and held that merely a procedure has been established by law, a person cannot be deprived of his life and liberty unless the procedure is just, fair and reasonable. It is thus now well established that the procedure established by law to not deprive a person of his life and personal liberty must be just, fair and reasonable. It must not be arbitrary, fanciful or oppressive. That the procedure to be valid must comply with the principle of natural justice. Last but very important thing under this article, that what happens to Article 21 during emergency. In idiom Jabalpur versus S. Shukla, popularly known as habeas corpus case, the Supreme Court held that Article 21 was the soul of the right of life and personal liberty, and therefore if the right to move any court for the enforcement of that right was suspended by the presidential order under Article 359, the detainee would have no locus standi to a writ petition by challenging the legality of his detention. In order that it must not occur again, the Constitution Act of 1978 amended the Article 359 to the effect that during the operation of proclamation of emergency, the remedy for the enforcement of the fundamental right guaranteed by Article 21 would not be suspended under a presidential order.